Hi, everyone. Pete Sardis for The Lawyer You Know. It has come to the end of the line for Elizabeth Holmes. Judge Davilas says she's going to prison, and she's going to prison in about a week, April 27th. So we'll talk about what the court's ruling was today and what you can expect from Elizabeth Holmes from this point forward. All right, let's back it up. If you recall, Elizabeth Holmes had asked the court to consider allowing her to have something as we call a supersedious bond, meaning asking the judge to allow her to remain out on bond pending the outcome of the appeal, because her lawyers argued that there was a substantial question that could warrant a new trial in her case based on the errors and the evidence that Judge Davila had let in during the trial. Judge Davila considered the motion, and the ruling is not only does Judge Davila not believe that she has substantial questions that could warrant a new trial, his position is that she has failed to prove her pre-appeal process would lead to a reversal. And this is interesting. In a quote, contrary to her suggestion that accuracy and reliability were central issues to her convictions, Ms. Holmes' misrepresentations to Theranos investors involved more than just whether Theranos technology worked as promised. Meaning, what he is saying in his order is that everything that was in here is not a matter of reliability and accuracy. It was a matter of safety for the patients at Theranos. So at this point, Elizabeth Holmes' bid for a supersedious bond is gone. Now, prosecutors, if you recall, had asked for Elizabeth Holmes to be taken into custody immediately to revoke her pre-trial bond status because she had taken a trip, or was supposed to take a trip, to Mexico, had bought a one-way ticket during the time when she was out on bond. If you recall, I did not think that this was a very strong argument. Actually, frankly, thought it was a little bit immature for the prosecutors to make this request, since the time for the ticket had already done and gone. She didn't leave after the conviction. Clearly, she didn't mean to flee. So at this point, the court did consider that issue and denied the government's motion to have Elizabeth Holmes' pretrial bond revoked. And he basically said this. He doesn't think that Elizabeth Holmes purchasing that one-way plane ticket to Mexico to be at the family friend's wedding, presuming that she was acquitted, was an attempt to flee. What he did say, though, it was an ill-advised decision, and it's not something that people should do on a regular basis just because it doesn't look good. And I frankly agree with Judge Davila, and I thought that he would not hold this against her. But at this point, I think that he has made the appropriate call. I think he has made a decision that is consistent with what the evidence shows. So at this point, the judge is not going to revoke Elizabeth Holmes' pretrial detention. He is not going to keep her from self-surrendering, which again is very important to Elizabeth Holmes, because if she self-surrenders to the federal prison on April 27th, she has the right to have some of her sentencing considerations reduced at the Bureau of Prisons classifications, which means she'll get a more favorable place. At this point, it looks like she's going to Texas for the time that she's going to serve. So what do we expect from this point forward from a perspective of motions and appeals and such? All right. We all know Elizabeth Holmes is going to appeal her judgment and sentence. There's no doubt about that. I'm under the opinion that most of that brief has already been written. It's just a matter of formalities to finalize some of the basic details that need to be in the appellate briefs. We already know that the lawyers were ordering transcripts for the trial as they were happening. So at this point, they have all the material they need. They've got all the court's orders. The docket is there. It's just a matter of having the clerk's office prepare the district court docket, meaning the case file, and transmit it over to the Ninth Circuit Court of Appeals. And I think you're going to see that Elizabeth Holmes' lawyers are going to file their appeal very quickly, right after the time commences, meaning once they've gotten all the records and all the transcripts and everything that the appellate court needs in order to set up the appeal. I also expect that Elizabeth Holmes is going to appeal the judge's denial of her supersedious bond. I'm guessing that the next thing you're going to see is a motion to the appellate court to have them reconsider this issue. Now, how does it work in appeals? It's a little bit different than what happens in the district court. In the district court, you normally, in federal court, will file a motion, and one of two things will happen. Either the court will rule on that motion and the opposing parties reply on the pleadings, meaning the judge will read whatever you've submitted, read whatever the opposing party has submitted, if they submit everything, and then issue a written ruling. This is the vast majority of the way that motions are dealt with in federal court. It's normally on the pleadings. There are opportunities for the court to hear live testimony, and we've seen it here in the Elizabeth Holmes trial more than once. Judge Davilas will actually bring everybody into court. He's read their motions, he's read the replies, and then we'll just kind of ask questions and allow the lawyers to put on live testimony to substantiate what is in the motions, at which point the court will then issue a written order. And that's kind of a big deal because in federal court, the vast majority of the orders are written because, again, it's something that the appellate court needs to be able to review. So the court's findings have to be inside of the pleading for the court to be able to determine what the judge was thinking and what decision-making factors went into the ultimate decision that the court made. So what's the appellate court process? More like the pleadings. They will file a motion. It'll probably be an emergency motion for reconsideration of the supersedious bond in the lower court. The court will then review it and make a determination if this is something that they want to hear outside the confines of the normal appellate process. You know, if this were Florida, if this were the southeastern United States, which is a lot more conservative, I would tell you that there is no chance in you know where that they would even consider this motion. They would just say, add it to your appeal and we'll consider it in due course. It's just the way things work. But the Ninth Circuit over in the west side of the country is a little bit different. It's a very liberal court. They're known for doing things that are not exactly the norm. They're known for doing a lot of out-of-the-box decision-making. And procedurally, sometimes they have a tendency to deal with things like this differently than what other courts in the country would do. So is it possible that Elizabeth Holmes could get the Ninth Circuit to reconsider this supersedious bond issue prior to ruling on her appellate decisions for the actual trial and her conviction? Yeah, it's possible. Now, is it a fast process? No. You all thought that the federal court process in district court was slow. I'm telling you what, it is lightning speed compared to some state courts, and it is fast as a process compared to what the appellate courts do. Understand that appellate courts are only considering issues on pleadings. Very rarely do cases actually have oral arguments. Yes, there are oral arguments in federal court where the lawyers will actually go and talk to the three-judge panel that is handling the appeal. But the reality is those are not as common in federal court, and especially the appellate courts, as they are in other courts. So the majority of cases are dealt with based on the actual pleadings. There are page limits, so there's a little bit of art to doing appellate work, because the key is to get the information you need to impart put together concisely and put together in a form that the appellate court can see your argument, what the issue is, or what you're going to be raising for them, your argument and the case law, and why the case law applies to your case, and then why they should reverse or do whatever it is that you need them to do. Can they ask for additional pages? Can they ask for an extension? Yes, that does happen. It happens, frankly, frequently in big cases like this. It may just be impossible to brief this case in, I don't know what it is right now, 50 pages or something close to that. So we shall see if the appellate lawyers ask for an opportunity to extend or to increase the page number or to extend the briefing schedule. I don't think they're going to actually ask the court to extend the time frame for them to file their initial brief. I think now that Elizabeth Holmes is going to prison, they're going to want to get that out ASAP. She's not going to want to wait 2-3 extra months for the appellate lawyers to get it together. She wants this filed now, I promise you. Now, the government acts and functions a little bit differently. The appellate lawyer that picks this case up has probably been following it since the trial stage. So I presume that the appellate lawyer from the government actually has a good feel for the case, has a good feel for the pleadings and the testimony. And I don't know if they've actually started their reply, but I promise you they've at least started the research and are organizing their thoughts, because ultimately the government, as the appellee, is going to be replying to whatever the defense, meaning Elizabeth Holmes, puts out there in the appellate initial brief. So they kind of know where it's going, but until they actually see it, they can't put their brief together. It is very common that the government asks for an extension of time to reply, because from their perspective, appellate counsel for the defendant, the appellant, Elizabeth Holmes, has had this case for a long time. They've got the transcripts, they've got the issues, they've had time to formulate their thought process, at which point many times the government lawyers will say, hey, I've got 10 other cases that I've got to brief because there's just so much volume. And I also just got their initial brief, so I have to be able to kind of break it down, expand on their thought process, review their research, review our research, and then get that to the courts. And it's very, very common. Frankly, when I did appellate work, federal appellate work for a while, it was the norm. Most of the time, the federal appellate attorneys would ask for an extension of time to brief a big trial like this. It's not normal. Normally, out of common courtesy, the lawyers agree to short, and I'm talking maybe like 30-day extensions. It's not uncommon at all. Let's see what happens in this case. I'm under the impression that Elizabeth Holmes is probably not going to be happy with her appellate lawyers granting extensions to the government. So we'll see how this comes together. But my gut is, even if the defense, meaning the appellate lawyers, they don't agree to an extension, there's a good chance that the government's lawyers will file a motion with the appellate court. The appellate court's just going to give them 30, 60, 90 days, whatever they need anyway. So it's not like it's going to preclude them if Elizabeth Holmes says no extension. So how long does this process take? Year, not uncommon. So we shall see. Elizabeth Holmes is apparently going to present to her facility on April 27th. That's about a week out. It's a little bit more, April 13th now. We shall see what's going to happen with her. She's going to be in process. She's going to be, put into a housing situation. They're going to evaluate her, just like the Bureau of Prisons does every day for countless other people. Yes, she will have the right to have contact with her children, with her husband, with her family. It's very normal in federal courts. All that stuff will be coordinated through her counselor at the Bureau of Prisons, at the actual facility itself. We've done some videos in the past on how all that process works. So if you're interested, go back and take a look at those, and we'll kind of go through the whole appellate process. We also go through the entire Bureau of Prisons classification and the Bureau of Prisons in processing procedure. So if you want, I won't go through all the details now, but those are in the previous videos. At that point, what do you think is going to happen? How quickly do you think the appellate lawyers are going to have Elizabeth Holmes' initial brief filed? Do you think that the appellate court in the Ninth Circuit is going to consider Elizabeth Holmes' supersedious bond issue separate from her, main appeal? Do you think there's any chance she is getting out and not serve her prison sentence until the appeal is decided? I think she's going to do 11 years, and she's going to do whatever 85% of that is. I think she's going to do it, and I think she's going to do it in straight time. So at this point, your guess is something I want to know. Let me know what it is. And if you have any questions, any comments, give them down below, and I'll keep you posted as these things happen. Thanks for joining me.
Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast, featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.